If debt feels overwhelming, you may be wondering if bankruptcy is your only option. Buried under a mountain of bills, phone calls, letters piling up, it can feel isolating. Every day brings a new wave of anxiety about the future, avoiding the mail, screening your calls, losing sleep at night, running the numbers in your head and seeing no way out. So, what is bankruptcy? At its core, bankruptcy is a formal legal process supervised by the federal court system. It is not a simple negotiation, it is a serious legal action that provides you with specific protections under the law. When you file, the court steps in as a referee between you and your creditors. An automatic stay is put into place immediately. It forces your creditors to stop collection activities, phone calls, letters, wage garnishments, lawsuits. Those actions must stop right away, giving you critical breathing room. There are several types of bankruptcy, but for individuals the two most common are Chapter 7 and Chapter 13. Chapter 7 is often called liquidation bankruptcy, a term that can sound scary, but is often misunderstood. In Chapter 7, a court-appointed trustee reviews your assets to see if anything can be sold to pay creditors. The law, however, provides generous exemptions that protect most essential property. This means most filers keep their primary home, car, retirement accounts, personal belongings. Chapter 7 is designed for people with lower incomes who can't repay their debts and often results in a full discharge, wiping out unsecured debts like credit cards, medical bills. Chapter 13, by contrast, is a reorganization repayment plan. It's for people with a steady income who still can't keep up with payments. Instead of selling assets, you create a manageable repayment plan that lasts 3 to 5 years. You make one consolidated monthly payment to the trustee, who distributes it to creditors under the plan. This lets you catch up on missed mortgage payments, car payments, and keep those assets. At the end, remaining eligible unsecured debt is typically discharged, giving you a fresh start. Both Chapter 7 and Chapter 13 offer a structured, legally binding way to resolve overwhelming debt. The choice depends on your financial situation, including income level, types of debts, significant assets to protect. To qualify for Chapter 7, you must pass a means test which compares your income to your state's median income. If your income is too high, you'll likely be steered toward Chapter 13. Either way, the process follows strict legal rules and timelines, providing a predictable, though challenging path to financial recovery. One of the most important factors to consider before filing for bankruptcy is its long-term impact. This is not a private matter, it is a public legal proceeding. When you file, the case becomes part of the public record, a future landlord, a potential employer. It is a permanent part of your financial history that cannot be erased. This lack of privacy can cause shame or embarrassment. The most direct and lasting consequence is its effect on your credit report and score. Chapter 13, up to 7 years on your report. Chapter 7, up to 10 years on your report. The moment you file, your credit score will take a significant hit. That makes it much harder to get approved for new credit, mortgages, car loans, simple credit cards. If you get credit later, you'll likely face less favorable terms. Lenders see you as higher risk and charge much higher interest rates. High interest can cost you thousands over a loan's life. That makes it harder to get ahead even after debts are gone. Rebuilding credit is possible, but it's slow and deliberate. It requires years of consistent on-time payments and responsible behavior. Bankruptcy is not a get-out-of-jail-free card. It provides immediate relief from creditors, but any eventual fresh start comes with significant baggage. You're trading a short-term debt stop for a long-term rebuild of your financial reputation. This is a serious trade-off that requires careful thought. Weigh the immediate relief of stopping collections against the long-term difficulty of navigating finance with bankruptcy on your record. If the legal finality and public nature of bankruptcy feel like too much, another path you might hear about is debt settlement. Unlike bankruptcy, debt settlement is not a court process at all. It is a private negotiation that happens directly between you, a company you hire, your individual creditors. The goal is to convince the creditor to accept a one-time lump sum payment that is less than the full amount you owe. If they agree, you pay the negotiated amount, and the creditor agrees to consider the account settled, closing the account for good. The process of debt settlement is not guaranteed to work. A creditor is under no legal obligation to negotiate with you or to accept a lower payment. Whether they agree to a settlement often depends on several factors: how far behind you are on your payments, who the original creditor is, their internal policies. Some creditors are known to be more willing to settle, while others may refuse to negotiate. and instead pursue a lawsuit to collect the full amount. To even begin negotiations, you typically have to stop making payments on the debt, which itself causes further damage to your credit score. This period of non-payment while you save up for a settlement offer can be risky and, stressful. During this time, which can last for many months or even years, your account will continue to accumulate late fees and interest, making your total balance grow larger. You will also likely face increasingly aggressive collection efforts from the creditor, constant phone calls, threatening letters. There is also a very real risk that the creditor could decide to sue you. If they win a judgment against you in court, they could then pursue legal remedies like garnishing your wages, placing a lien on your property. Furthermore, if you successfully settle a debt for less than you owed, there can be tax consequences. The amount forgiven is often considered cancellation of debt income by the IRS. This means you might receive a 1099-C and be required to report that forgiven amount as taxable income. If you choose to work with a for-profit debt settlement company, they will also charge significant fees, often a percentage of the debt, further reducing your potential savings. To make an informed decision, it is helpful to place bankruptcy and debt settlement side by side and compare them across a few key areas. The first and most fundamental difference is court involvement. Bankruptcy is a formal legal process overseen by a federal court. You receive legal protection, like the automatic stay, but you must also follow the court's strict rules and procedures. Debt settlement involves no court whatsoever. It's a private negotiation between you and a creditor, offering more flexibility but none of the legal protections bankruptcy provides. This leads directly to the question of privacy. Bankruptcy is a court proceeding and creates a public record. Your name and the fact that you filed will be accessible to anyone who looks. That can feel exposing and is a major drawback. Debt settlement is far more private. Details are known only to you and to the creditor and to any company you hired to help. But the settlement result, an account marked settled for less than the full balance, still appears on credit reports. Next, let's consider flexibility. The bankruptcy process is rigid. Timelines. Payment plans in a Chapter 13. Rules for what you can and cannot do with your finances. There is very little room for negotiation once the process begins. Debt settlement is much more flexible by nature. You and the creditor can theoretically agree to any terms. The problem is the power imbalance. The creditor holds most of the cards and can refuse to be flexible, leaving you with no deal and potentially worse off. Finally, and perhaps most importantly, the credit impact. Both options will seriously damage your credit score. Bankruptcy stays on your credit report for 7 to 10 years, making it very difficult to borrow. Debt settlement also hurts credit because it requires stopping payments, which leads to delinquencies. The settled account status is also a negative mark. Both paths create significant, long-lasting obstacles to rebuilding financial health. With a clearer understanding of both options, we can start to see which path might be more appropriate for different situations. Bankruptcy, particularly Chapter 7, is often a tool for those who are in the deepest financial trouble. You should consider bankruptcy if you have very little or no realistic ability to pay back your debts in the foreseeable future. If your income is low or unstable, credit cards, medical bills, personal loans, bankruptcy offers a definitive and complete fresh start that other options cannot provide. It is for the person who needs immediate, powerful legal protection from lawsuits and wage garnishments. Chapter 13. Bankruptcy, on the other hand, is designed for a different scenario. You might consider this path if you have a reliable, steady income, mortgage, car loan. If your primary goal is to keep your home or vehicle and you can afford to make a structured, consolidated payment over time, Chapter 13 provides the legal framework to force creditors to accept a repayment plan. Debt settlement might be a reasonable option for a more limited set of circumstances. Consider debt settlement if your financial problem is not overwhelming, but is instead concentrated in a few specific accounts, 1 or 2 high-balance credit cards. To be successful, you generally need to have a significant lump sum of cash available, or the ability to save it up quickly, to make a compelling offer to the creditor. You must also be willing to take the risk that the creditor may say no, continue collection efforts, or even sue you while you are attempting to negotiate. It is for the person who wants to avoid the public record of bankruptcy and has the resources and risk tolerance to try for a private deal. Imagine Maria, who has a good job but faced a sudden medical emergency that left her with $80,000 in medical bills, on top of her regular expenses. She can't possibly pay it all, but she wants to keep her house. Chapter 13. Repayment plan could be a good fit. Now consider Jamal, who lost his job and has racked up $40,000 in credit card debt just to get by. He has no income and no prospects for repaying anything. Chapter 7 might be his most logical path to a fresh start. Finally, there's Sarah, who has a single $10,000 credit card that got out of hand. She just received a small inheritance and can offer the creditor $4,000 to settle it. For her, debt settlement could be the quickest way to resolve that one specific problem. Before making a permanent legal decision like bankruptcy, it's important to understand all your options. I've partnered with a trusted debt relief network that offers a free, no-obligation assessment to help you see whether debt settlement or another alternative fits your situation. No pressure, just clarity. The link is in the description. Big decisions deserve clear information. If this video helped you, hit like, subscribe, and share it with someone who needs it. Remember, debt is a situation, not a life sentence. It does not define who you are as a person. Millions of good, hardworking people find themselves in this exact position for countless reasons: job loss, medical emergencies, simple mistakes. The most important thing you can do right now is to stop panicking and start planning. Getting clear on your options is always the first step forward. You can get through this, and you can build a better, more secure financial future on the other side.